Yusuf Ali S.A.N., who appeared for the appellant, he formed a 3-man panel of justices headed by Justice Olukolade Bada that he filed a brief on the 3rd of March 2017 and the replied brief for the first, second and third respondents on the same day. He added that the appellants also filed a notice of preliminary objections to the cross-examination of the third respondent as well as list of authority filed on the 14th March 2017. According to Yusuf Ali S.A.N., the appeal is important to the appellants as they started a process of recounting of ballot papers at the Edo State Governorship Election Petitions Tribunal, but the exercise was cut short by the respondents despite the order of the tribunal for the recount. The petitioner's counsel, who cited various authorities to buttress his point, said the action of the tribunal in yielding to the objections by the respondents amounted to frustrating its own orders. He insisted that even if the Electoral Act prescribes 14 days for the petitioners to prove their case, the tribunal is bound to allow the completion of the recount since it has 100 days to entertain the petition. He therefore submitted that the Court of Appeal should grant the application for the completion of recounting of the ballot papers. In their argument, counsel to the first respondents Onye and Monye, counsel to Governor Godwin Obaseki, Wole Olanikpeku S.A.N., and counsel to APC Lateef Fagbemi S.A.N., who upheld their preliminary objections, said since the petitioners have already closed their case at the tribunal, there was no room for recounting. They said the tribunal's ruling on the issue indicated that the court does not have the powers to add more days for the petitioners since they have utilized their 14 days. The respondents in their submission said the petitioners had demanded for scanning of INEC materials and at that time did not ask for recounting, adding that since the petitioners were aware that they had 14 days, they should have started the recounting well on time. Addressing the justices in the cross appeal filed by the APC, counsel to the third respondent, Lateef Fagbemi S.A.N., said the tribunal had no powers to order the recount of the ballot papers since the documents were not tendered in evidence before the tribunal. Fagbemi S.A.N. was of the view that the petitioners should have filed a written application before the tribunal for the documents to be tendered, but said that the petitioners only subpoenaed an INEC official who produced the ballot papers at the tribunal and called on the court not to allow the appeal. In a reaction, counsel to the respondents in the appeal, Yusuf Ali S.A.N., said there is nothing stated in the Electoral Act that a document must be tendered in evidence, and added that it was not necessary for a written application to be made. Yusuf Ali S.A.N. said when a party brings a document before a court, the party determines what to be done with the materials, and emphasized that on the issue of the ballot papers, the petitioners stated in their petition that they will recount the ballot papers. Yusuf Ali S.A.N. therefore prayed the court not to allow in the cross appeal by the APC.
We've done all the arguments we ought to do and we hope for the best. It was that the tribunal shouldn't have stopped us from counting on any account, and we felt it was injustice to us by stopping the counting which had started. Their own appeal was that the tribunal shouldn't have given us opportunity to count at all.
The appeal was lodged by the petitioners who claimed that they were stopped abruptly from counting the ballot papers which the court had earlier ordered. Issue of ballot recount was part of the things they needed to prove that they actually won by a majority of lawful votes. If you fail to do that, you cannot blame the tribunal or ask the tribunal to make or substitute its own view for the evidence that will be before the court.
Why the respondents in the Edo State Governorship Election Petition are relying on Section 41 subsection 10 of the Electoral Act that the petitioners have 14 days to prove their case and allowing them to recount the ballot papers amount to amending the rules. However, counsel to the petitioners, Malam Yusuf Ali S.A.N., who cited relevant authorities, says rules and orders of court are meant to be obeyed. According to him, the tribunal had ordered the recounting of the ballot papers and should be completed. The appeal court has reserved judgment on the two appeals before it. From the Court of Appeal sitting in Benin, Best Mbiere reporting.